What happens if I refuse a breathalyzer test in California? Well, there's two different breathalyzer tests that have different consequences if you refuse them. One of the breathalyzer tests is called a preliminary alcohol screening test. That's generally a test offered as a field sobriety test, and it's offered on the side of the road with the officers. They will say, blow on this machine to see if you're sober or not enough to drive. That test is considered a field sobriety test, so it's voluntary. As long as you're over 21, you can refuse to take that test, and they can't use it against you, even your refusal to take the test. Once you're arrested, they place you under arrest for driving under the influence, and they offer you a chemical test. You're required to be offered a blood or breath test, and you must take that test. If you do not take that test, your license would be revoked for 1 year by the DMV, regardless of what your chemical test results were. If you refuse to take that test, many of the agencies will get a judge to sign a warrant, and they will draw your blood anyway. So they'll have your chemical test results, as well as charge you with refusing a chemical test. So you could lose your license for 1 year, even if your blood alcohol level is low. So you definitely are required to take the second test if you're lawfully arrested for a DUI. If you're under 21, your license would be revoked for 1 year. If you're over 21, it's just a field sobriety test, and they can't use that against you in court, even your refusal to take that test. You can refuse all the field sobriety tests because they're a violation of your Fifth Amendment rights against self-incrimination. So refusing to take those cannot be used against you. But once you're arrested, the evidentiary chemical test is given, and that one you're obligated to take by the law of the DMV, or you can lose your license for 1 year.